Now, honorable senators, I have another communication to make. I have the following communication to make arising out of points of order raised relating to a personal statement that was made by the Senator for Nakuru County, Senator Tabitha Karanja Keroche MP. Now, honorable senators, as you may recall, at the sitting of the Senate held on Thursday, the 29th of May 2025, the Senator for Nakuru County, Senator Tabitha Karanja Keroche MP, made a personal statement pursuant to Standing Order 58, thus so to inform the Senate and the general public that the Senator was in good health and had not been hospitalized as reported. In the statement, the Senator indicated that there was a smear campaign orchestrated by the Governor for Nakuru County, who is using public resources to malign her character. Upon the Senator's conclusion of her statement, I drew the attention of the honorable senators to the provisions of Standing Order 101-1, which states as follows. Majority Leader, you may walk in. This is fairly long. Now, upon the Senator's conclusion of her statement, I drew the attention of honorable senators to the provisions of Standing Order 101-1, which states, and I quote, "Neither the personal conduct of the President, nor the conduct of the Speaker or any judge, nor the judicial conduct of any person performing judicial functions, nor any conduct of the head of state or government or representative in Kenya of any friendly country, or the conduct of the holder of an office whose removal from office is dependent upon a decision of the Senate, shall be referred to adversely except upon a substantive motion of which at least 3 days' notice has been given." This prompted several points of order from Senator for Kakamega County, Senator Dr. Boni Halwale, MP, the Senator for Nairobi City County, the Honorable Senator Eben Sifuna, MP, and the Senator for Narok County, the Honorable Senator Ledama Olekina, MP. Honorable Senators, in the point of order raised by Senator Dr. Boni Halwale, the Senator sought the intervention of the Speaker to expunge the statement made by Senator for Nakuru County for infringing provisions of Standing Order 101-1. Senator Sifuna's point of order was in connection to what constitutes adverse reference to a holder of an office whose removal from such office is dependent upon decision of the Senate. On the other hand, Senator Olekina's point of order was in support of the point raised by Senator Dr. Boni Halwale. Honorable Senators, after listening to the points of order by the three senators, I undertook to issue a substantive ruling on the application of Standing Order 101-1 in the Senate debates. In preparing this communication, the following matters came out for determination. 1, what is the scope of Standing Order 58? And 2, what constitutes adverse reference in the context of Standing Order 101-1? Allow me therefore to address the first question, which is the scope of Standing Order 58. As honorable senators are aware, Standing Order 58 states, and I quote, "During statements hour, a senator may, by the indulgence of the Senate, explain matters of a personal nature, although there is no question before the Senate, but such matter may not be debated." This standing order has previously been used on several occasions in this Parliament. For instance, on the 17th of September 2024, the Senator for Kihika County, Senator Godfrey Osotsi, MP, made a statement on his nomination to the position of Deputy Party Leader of the Orange Democratic Movement, ODM. In the statement, the Senator's comment centered on his elevation to the said position and the heavy responsibility placed on him to assist in steering the party's policy and direction on pertinent issues affecting the country. The Senator also used the opportunity as a rallying call for the party to remain united. On 31st of July 2024, the Senator for Marsabit County, Senator Mohamed Chute, made a statement thus so to clarify his appearance before the Ethics and Anti-Corruption Commission, EACC, on the 11th of June 2024. In the statement, the Senator clarified that his appearance before EACC was on invitation by EACC to provide information arising from several complaints the Senator had filed regarding misappropriation of funds in Marsabit County. In another instance, on the 2nd of May 2024, the Senator for Nandi County, Senator Samson Cherargei MP, made a statement concerning the denial of access to his verified X, formerly Twitter, account. Senator Cherargei expressed concern on his lack of access to his account, which the Senator argued was tantamount to denial of his ability to effectively engage with his constituents and the public. Now, Honorable Senators, ordinarily, personal statements in the Commonwealth are mechanisms that provide a limited opportunity for members of Parliament to explain matters of a personal nature. By practice, personal statements are not subject to intervention or debate on account that they are personal. As such, therefore, the contents of the statements are submitted to the Speaker to ensure that they are confined to matters of a personal nature, and the members granted leave by the Speaker to make such statements are not allowed to depart from the approved text. The approval of such statements is given with a high degree of caution on the part of the Speaker to ensure that parliamentary proceedings remain focused and not derailed. In this respect, Honourable Senators, personal statements, as Standing Order 58 implies, should be giving explanation and should be restricted to a specific matter that a senator wishes to explain. While the facts of the matter may be stated briefly, this should not stray into general arguments or seeking responses. These are the parameters that have been and will be applied when considering requests for personal statements. I urge all honourable senators to observe them when preparing personal statements. Now, honourable senator, the second question that required my determination is what constitutes adverse reference in debates within the meaning of Standing Order 111. As honourable senators are aware, adverse reference in the context of parliamentary debates means unfavorable or defamatory statements or allegations of an incriminatory nature against individuals or institutions. Standing Order 111 is a safeguard measure that protects individuals who are not in the Senate and therefore lack the privilege to defend themselves. This is rooted in the principle that those who are not present in the Senate and hence cannot respond to comments made by honourable senators are not targeted or maligned in the course of proceedings. While all senators are entitled and indeed obligated to bring to the attention of the Senate any matter which one believes merit to be investigated to safeguard good governance, this must be done without resorting to personal attacks on the office holders. It is necessary, therefore, to exercise caution and restraint not to delve into debate that may form grounds for removal from office. There is an elaborate procedure for such debate as provided for under Articles 145, 150, and 181 of the Constitution, Section 33 of the County Governments Act, and Standing Order 78, 79, 80, and 80, which allow the Senate to make a distinct decision on such matters. Comments that touch on the grounds for removal should therefore be reserved for the appropriate substantive processes, while general matters of concern may be addressed through the relevant legislative tools. Honourable Senators, going forward, therefore, I expect that we adhere to the provisions of Standing Order 101 in debates in the Senate. Moderation, civility, and restraint are some of the hallmarks of parliamentary debate. It will be out of order for any senator to make adverse reference to the conduct of office holders referred to in the standing order without a substantive motion. However, statements of fact are permissible in debates on a question before the Senate. As regards the application of Standing Order 58, statements must be confined within the scope I have highlighted, and they must be submitted to the office of the clerk for processing. Likewise, going forward, the Presidium will strictly approve statements that have been processed in accordance with standing orders. For avoidance of doubt, the Chair will not entertain requests for approval of statements while seated in the chamber. The Senate is therefore guided accordingly. I thank you, Honourable Senators. I thought this statement is elaborate enough. Yes, Senator Fernandez.
Thank you, Mr. Speaker. I need your guidance on a number of issues. While I appreciate, and as a member of this House, I will abide by your directions. So, Speaker, what troubles me is whether a witness can discuss the conduct or the state of a member of the Senate who sits in the Senate. Because, Mr. Speaker, I need your guidance. When you look under Article 125 and Article 124 on committees and on compelling of witnesses, and Mr. Speaker, looking at Article 96, as 96, Article 96, 4, the Senate shall participate in the oversight of state officers by considering, among others. So, Mr. Speaker, I really wanted your guidance that whenever we invite witnesses to appear before the House, under standing orders, looking at a standing order 101, and in your power of standing order number 1 of the standing orders, do they have powers to discuss the conduct of members of the Senate who are sitting in plenary, whether they are present or absent, Mr. Speaker, so that we are aware, so that is it possible, because, Mr. Speaker, I'm at a loss, that I cannot discuss the Senator of Nairobi, for example, substantively, without a substantive motion. So, Mr. Speaker, in that same spirit, one of the witnesses yesterday purported, and I'm happy and I'm grateful that you did stop that, pursuing that line, but is it possible to strike it off the record of the Senate, those comments that were made in bad faith? Because, Mr. Speaker, the principles of natural justice demands that you must hear both sides of the story, Mr. Speaker. Therefore, I'm requesting humbly that those comments were made in bad faith by the cabinet minister in charge of Interior, Mr. Speaker, with a lot of tremendous strength. In fact, when I was in school, he never taught me. He was among the librarians in the law school that I was there, Mr. Speaker. And even the allegations is that he was doing STGs in some of the classrooms, Mr. Speaker. So, Mr. Speaker, I really want that matter to be put to rest. Because the clients, a number of clients, including the great voters of Nandi, have never slept throughout the night. Because they know me as one of the brilliant, hard-working, top-performing senators of this Republic of Kenya, Mr. Speaker. Can you issue a directive that whenever a witness appears before you in plenary, and I'm happy, Mr. Speaker, I'll be eternally grateful for what you did, even before our committees, the chair of roads, before any committee, Mr. Speaker, can you direct that the witness does not have power to discuss any conduct of any member, either in plenary or in any other form, Mr. Speaker? Then, as they say in Catholic, sema neno moja tu na roho yangu itapona. I thank you, Mr. Speaker.
Yes, Senator for Nairobi City County.
Yeah, Honorable Speaker, now that we are discussing the question of specific substantive motions, if you look at Standing Order 101-4, Honorable Speaker, it requires that we should not impute improper motive on any other senator. And it talks about no senator shall impute improper motive to any other senator. I want to know, Honorable Speaker, whether when this standing order speaks of no senator, it includes the chair. Because, Honorable Speaker, yesterday, there was an imputation from the chair that some of us come here to collect TikTok videos. And it is something that has upset me greatly, Honorable Speaker, because I was elected to this house to represent people, and most of those people look like me. And, Honorable Speaker, I remember very well 2 famous governors in the 2013-2022 period who used to produce very good content. They were dancing on platforms. One of them is now a cabinet secretary, the other is the Speaker of the Senate. So, Honorable Speaker, when did it become wrong for us to end up on social media, depending on the work that we do, and whether it is correct for the chair sitting there to impute improper motive on a senator who has come to do the job that he was sent here to do by the people who elected him?
Honorable Senator for Nairobi City, you're out of order. If you read Standing Order 101, you cannot discuss the conduct of the Speaker in the manner you are doing. Go back to Standing Order 101 and appreciate its contents. For as far as this point of order raised by the Senator Fernandi, I will look at the Hansard and give a substantive guidance on that particular matter. Next order. Yes, Senator for Nakuru County.
Honorable Speaker, you have not answered my question.
Senator for Nairobi County. I have clarified on that particular matter, and that is the position of the chair. Senator for Nakuru. Senator for Nakuru, proceed, please.
Thank you, Mr. Speaker, sir. Senator for Nairobi, thank you. Maybe. Thank you.
Proceed.
Yeah. Just for a clarification, I've heard your statement, and as you protect those people who are not in this house, kindly can you also protect us, we as the senators who are in this house? Because the minute you bring a statement like the one I didn't start it. The person that I mentioned is the one who had started it. So I need to clarify to the people of Kenya that I'm not sick. Because anywhere I was on the street, people are just asking me, are you well? Even up to today, people are still asking me, are you well? Even here, when I'm entering, I think there's a new sergeant at arm who is telling me, oh, nice to see you. You are well. Are you healed? So I had to come and really make a clarification so that Her Excellency Susan Kihika should not go again on a live television and start claiming that her senator is sick just because I'm doing my job diligently and wishing him even to die, that I'm 3 minutes to the grave, and where I'm only doing my job, and she's feeling the pinch of the oversight role I'm playing in Nakuru County. So that's why I came. But I can never start anything and mention her name here if it didn't come from the public. So I came here because that thing came from the public, and I wanted to clarify to the people that I'm well. And senators, I repeat it again, I'm healthy and fit, and you can even, like a host, and you can even look at me, and I've never been sick, and I thank God. And those who are sick in hospital, we continue praying for them to get well. But anybody who can wish anybody to be sick, that person must be sick up here. So I sit well.
Senator
Thank you, Mr. Speaker, sir.
Senator for Nakuru, I can assure you that balance will be guiding on the applicability of 101. Yes, Senator for nominated Senator Veronica, certainly it's not a point of order.
Honorable Speaker, is it in order for the Senator for Nakuru to almost put a censure on the direction you have read in the communication you've given to the House? Senator
Veronica, I've already guided the Honorable Senator.
It is very wrong for her to continue while she knows she actually went on the same TVs and actually spoke on the personal issues of the governor for Nakuru.
Senator Veronica, let us not generate this into an argument. Senator Fernandez, just have a seat, Senator Veronica. Senator for Nakuru. Senator for Nakuru, I've given you a lot of latitude to ventilate your matter, and I've advised you, because what I picked from your lengthy intervention is, as we seek to protect, we are not really protecting, but this is what you say. As we seek to protect those who are not in the House, we should also not lose sight on protecting those who are in the House. I am quoting what the senator said. Honorable senators, a ruling has been made by the chair. Kindly abide. Next order. Next order.